moving to another matter, is the social justice, human rights, and what comes to my mind, and I'd like to ask you, sir, is that have we been able to empower the women in India? Are you satisfied, or with the steps taken so far?
Well, the steps are both legislative law and adjudicative law, both. And there is a new field called a new field of studies, but it's a very old happening, which is violence against women and sexual harassment. Okay, so on the legislative front, India has got great progress from Dowry Act, totally amended. The post-Mathura amendment, Mathura was an open letter to the Chief Justice of India, which no country has seen like of. I signed it, I drafted it, Lotika Sarkar, Baswa Dagamba, Raghunath Kelkar signed it. We wrote an open letter to the Supreme Court on the rape case, but left it for the court to realize the error of its ways. And we said the court was patriarchal. We committed open contempt in a public letter. After that, Justice Krishna has said in his judgment that an ounce of judicial sensitivity is worth more than tons of law reform. That was how he begins his sentence, 1 year after Mathura. So we made our point. Supreme Court itself would correct its ways. It not look at the mark on the body of the victim to find whether the rape has been committed. I'm violated, why should I have marks on my body? The idea about if the rape happened, the woman should defend herself. And therefore in the defense there will be some marks on the body. If there are no marks on the body, then there is no rape. Now we can't give judgment like that. No way. So we did that in open letter in 1979. Then in 85, we reformed they are called Mathura Amendment. We said there should be a presumption of guilt on the part of the court that a person who is in dominant position has raped the woman. If the woman comes forward and says it's raped, it is there. Priest, professor, doctor, senior lawyer, who are in dominant position of power, for example.
Yes.
We call it power rape, but the legislature did not go that far. But it says certain position, dominant position. So fine.
Say superintendent of a remand home and all that, yes.
Institutions, everywhere. So legislative law, and there's the Indecent Representation of Women Act, which is worth a look at, people don't realize it, in advertisements. So legislature has, the 491A of Criminal Procedure Code or something, which deals with dowry murder cases, and in-laws are responsible for dowry murder. And that has generated rights for men kind of movement, backlash at the moment. So it has been a number of, legislatively we are very well advanced. Judicially, rape culture is practically gone out of judiciary.
Law enforcement.
No, judiciary has enforced the law fairly strictly. Earlier, there was a thing called two-finger test.
Yes.
Under which you had a vaginal examination, a habituate. The bar said the woman is habituated to intercourse by many people from the physical layer.
So that attitude has changed.
That has changed.
Yes.
And that thanks to women's movement, thanks to most of us, it has changed. We kept a constant vigil. So it is I'm satisfied. But it's a situation of glass half full and half empty.
Okay.
Yeah, because enforcement, there are still many, and the mass violence is women, like in situations you're mentioning, communal riots, so many parts. But atrocities against women continue. And we don't have a way of finding out a suitable enforcement policy. We don't have an official policy of 0 point tolerance. I don't know if the rapes occur in army or not. Male rapes, I don't know, but you have a lot of experience.
So, zero tolerance policy is yet to be sort of become operational, fully operational.
Yes. So this is this. So we must shop around and get a proper model. America has a whole act called Violence Against Women Act. That's why federal statutes. Congress passed it. We don't have a similar thing in India. Why not? So it is also intergenerational struggle. Every generation must concentrate on this issue. Just to be atrocities act is untouchable. There is no atrocities act against women. There is separate offence of rape, separate offence of sexual harassment, separate offence of grievous. Why? Put it in one place and call it atrocities, mass atrocities, conspiracy. Everything has to be code for women. There should not be separate laws we search for. Any kind of violence against women should be in one place. And there should be legislation, comprehensive legislation for that. And now the Supreme Court has related this idea of intersectionality. Yes. Supposing you are deaf and dumb or blind and a woman and scheduled caste and you are raped. What kind of punishment you will get for? Violation of Disability Act, or you will get violation of rape, or violation of something else? Multiple disadvantages flow from one class of persons, not marginalized. So we should think afresh. And we had in Delhi University, when I was teaching there, a Young People's Law Commission. Law Commission is normally set up by the state.
Even then, Young People's Law Commission.
And we propose various sorts of law reforms. That's where the students learn legislative drafting. We didn't want to be to chance, vagaries of judicial draftsmanship. India is the only one of the few countries where legislative drafting begins. Legislation begins with the following: whereas it is expedient in the year so and so of the Republic, we enact the following law. Now we always ask the question, why does the legislation start with whereas it is expedient? Why doesn't it say whereas it is necessary, whereas it is good for society, where it is just? So positive law is a pure act of will. What Parliament does, expedient. It is necessary for doing politics of development. So this is the point. It shouldn't be expedient legislation.
Yes.
It should be principled legislation.
Yes. Thank you. Here we come to the end of this video, and in the next video we would talk about the matters relating to curbs on dissent and these polarization in the society. Thank you.